my court, and I would run it in the way I see fit. And if you don't like it, you can leave.
So Roxy,
Yes.
practicing law from the bench, right?
I think you can't.
Are you practicing law from the bench? Are you representing
You may like that, Mr. Timmy. But I hold you in contempt and have you detained. Stop wasting my time.
Oh no, nothing's worse than Timmy with authority.
Bye-bye now.
Timmy.
Where do you think you're going? He goes, you're behind the bench, you're wearing a robe, I've just said to you, corpus juris secundum, he goes on this, yes, which part of I've removed your jurisdiction you don't understand? Yeah. He said, remember, whenever we come into a courtroom, he goes, there is the agents and there is the principals. It only takes one of the principals to remove your jurisdiction so that you do not have presiding power in the courtroom.
Exactly.
Three
words in one
direction. That's how the system works. And he goes on, well, it's been how the system works since I've been doing this in the 1970s.
Yeah, yeah. So it must
have worked. Again, he was an old fellow that was, as he said, he's self-represented. He's another one that can't stand back. But he just turned around and said, when it comes down to it, all you're asking for when you go to court is, you're asking for them to make a non-impartial, non-biased decision. Sorry, an impartial decision that's not based on bias.
Let's not forget throwing the Fair Trading Act 1986 in there for good measure, Section 13, because they're also getting paid to work.
That's been a very touchy subject in the court.
Section 13 and Section 9, you said, I think, to me. It was...
Yeah, Section 9 is if you're an individual, Section 13 is if you're a professional.
Yeah.
Professional capacity, so
they're all getting paid. They must all trade fairly.
They're all getting paid for doing it, and I mean that's what Judge Harrop said as well. He said, well, you said like when I put it in my applications, the Commerce Commission Council tried to say it didn't apply, and he goes, well, how does it not apply? We're trading here today, are we not? And he goes, no, we're not, Your Honour. He goes, as long as what are you doing? He goes, as long as you're asking me to make decisions through trade.
Exactly. Trading information, are they not?
Yeah. It was quite interesting to find out when they were going through my estoppel letter that he agreed with the Imperial Laws Application Act, the Secret Commissions Act, the Contract and Commercial Laws Act. He agreed with everything I'd written in the estoppel letter and told them that if they were to receive one from me again,
and make that argument.
Well, he said it's not being argued today, and I thought maybe I should have been. But he went through it with me, and he goes on this. So you do have an understanding of what it's meaning. And I said, I've got a fairly good understanding. He said, and he asked me, is there any reason why you didn't put the Public Trust Act in? I said, why would I want to bring common law back in when I removed the contract and commercial laws? And he goes on, that's exactly right. Then the lawyer went, no, that's wrong, Your Honour. And he goes along, no. He goes, he's actually quite correct. He goes along, and your client would have been best to actually adhere to that letter, because if he had enforced it, he goes, this case would be going a completely different way.
Yeah.
But then it was funny in the end anyway, because I only asked 3 questions and destroyed her credibility altogether.
What were the questions?
When you turn around and say to her, well, she was being cross-examined by the lawyer, and she was saying that the Commerce Commission had been looking into mobile traders since 2020. So straight away I wrote down 2016, because that was when I worked for the last company that I worked for. And then she was going on about that our contracts had no end dates. Okay? And then she was talking about the fact of my experience within the industry, which clearly she had not even looked me up at all.
Yep.
Otherwise she would have known that I'd been in it close to 20 years.
2004 I think it was, you said, wasn't it?
Yeah, around 2004, 2006, somewhere around there. And so my first question that came out of my mouth is, so I put it to you that you've just told the court that the Commerce Commission has only started monitoring mobile traders since 2020. She goes, that's correct. Okay, I will put it to you that that is incorrect, that the Commerce Commission has been doing them since at least 2004, when I started in the industry. And she goes, yeah, and possibly before that as well, because Mangere Budgeting Services was always in the news before 2004 about mobile photo trucks.
Yep.
And she goes on and goes, I don't believe that's correct. And she looked over to the back of the courtroom to this guy, and the look of the guy's face was like this type thing.
So he's back on the computer looking it up.
Yeah, so what the judge said he was going to do was he was going to go away anyway and check out everything I had said.
Right.
Because I said to, what was really bad for her in a way was the last company I worked for, she was the person who cleared the paperwork that I had designed.
Right.
And yet here she is trying to say, this is what she said. I don't understand how you think your paperwork can be up to standard. Who did your paperwork? I did. The same as I did it for PINAC NZ when you were the person who was overseeing it.
Right.
And I said that's why I pushed to your fact of 2020 because I worked for PINAC NZ in 2016.
Yeah. And you knew they were monitoring back then.
Yeah, and I said back before that I worked for a company called Good Guys back to 2012 and 2008 backwards I worked for a company called Stop the Shop. I didn't have any involvement in the paperwork with Stop the Shop, but I did have a bit of involvement with Good Guys. And she goes along goes, okay.
So you were clearly more experienced than she was if she only started in 2020.
Well, yeah, and I turned around and said, when I turned around and said to, like, the judge said to me, hold on, can I just clarify something here? It's like, yep. He goes on goes, so you are saying to me that she is saying that she's been doing it since 2020. Mm-hmm. And I was like, yes, that's right. And you're saying, no, that's incorrect. I'm saying, yes, that's right, that's incorrect, because she's the lady I dealt with when I worked for the other company in 2016.
Yeah.
And I was based in Wellington, and then he goes, where I am now? And he goes, I'm going to share. And I said, and the company was based in Auckland. And he goes, okay. I said, so the reality is, she could not possibly have only started for the Commerce Commission in 2020 as she stated, when I dealt with her in 2016.
Yeah.
Her answer for that, he looked at it and goes, what do you have to say there? Oh, I meant I started doing that mobile investigation in 2020. So then what you told before is incorrect.
Mislead the court much?
Yeah, and so then he just goes, okay, is there anything else you'd like to do? I said, yes. So if you look at the invoices on tab 7, I said, she's saying that there's no end dates. I'll refer you on to the 2/3 of the way up page, start and end dates. He goes on this years. She's gone by the end dates as the 2020 part, saying that we've been trading. She goes on here. If Your Honour would look above the end date, it says start date, December 2019. The time when I said was the last time we had done sales in our business. And he goes, yes, I do see that. And she goes on goes, yes, but there is no end date. And he goes on goes, would you look at tab 7 and look at the invoices? He's saying right below start date, it says end date. It does say that. And she said, but he didn't give us all the information we required, Your Honour. And he goes to me, and what's your answer to that? And I said, well, the answer to that, Your Honour, okay, if you look at tab 13 that she's referring to, because on this year, 2.1 says from the 1st of January 2020, yes, through to April 2021, 1st of April. Years on this years. Now, if you stop trading in December 2019, yes, yeah, and your normal, our normal holiday period was from the 19th, 20th December through to about the 2nd week of March, we would take off. Right. And he goes on goes, yes, right. So if you come into the 3rd week of March, what happened in the 3rd week of March on March 2020? We hit COVID lockdown.
Right.
And he goes on goes, yes, we did. I said, right. And one of the conditions of COVID lockdown to be able to operate a business was there had to be 2 metre distance. And he goes on goes, yes. We ran a van that was 2.4 metres in the back of it. It was a half a metre counter. He goes on this year. So therefore, we could not put anybody inside the vehicle and trade because we would be breaching the 2 metre rule. So we figured it was safer just to not run the business, and how the government was paying out everyone of their subsidy, we'll go with that way because that's the safer way.
Sure.
So, and she goes, but you had money coming in, and we've got bank records and stuff like that. And before I could even turn around and say, well, hold on a minute, he goes, hold on a minute, that's hearsay. And you're going off of what other people have told you, and they're not here to question.
Exactly.
So I'm not allowing you to be able to give hearsay evidence against counsel. You need to control your witness. And so,
not going the way they'd planned.
Yeah. So I don't know what the actual outcome of it is going to be. But going on the fact, he asked me did I want to give evidence. I said, well, no, I think I've created enough doubt with 3 questions. Yeah,
all you got to do is create beyond reasonable doubt. And clearly, if she's misleading the court, she's not telling, all of the truth. Because you're supposed to swear to tell, the whole truth and nothing but the truth. And that's not the whole truth.
And it's funny you say that, because I did turn around and say to her at one stage, I remind you, you're under oath.
Yeah. Remind you further of Section 108 of the Crimes Act. Yeah.
And she said, I'm aware of that. So I said to her, then you'd also be aware that the Commerce Commission has been running these programs, these monitoring programs for many, many years. And if you're not, why are you not? And then she says, and then she came back with a question with me. She goes, but I'm saying that you've got payments, you've had payments coming in after the accounts were
December 2019. Yeah.
So I said to her, well, if you've worked for the Commerce Commission long enough and you've been doing mobile trading like I know you have for at least 5 or 6 years, she goes on this year, you should be aware by looking into these companies that these companies sign people up. She goes on this, yes, but there's no end date for the payments to stop. And I said, hence why on the form it says, a box there says, I would like my payments to continue once it's finished paid off. And she goes, yes, that's correct. So which part of that do you not understand? A lot of customers that deal with the mobile industry want their payments to continue so they don't have to restart another direct debit and cost them more money. So we give them that option to leave it going, and when we do it through the third party direct debit provider.
Yeah, it'll cost you two bucks to set up an automatic payment or a direct debit. Exactly.
Well, yeah, exactly. So I said, and she said, yes. She goes, well, yes, I do know that. Then I'm not sure why you're questioning it. So to her.
Really?
And the judge just went, I'm not sure either.
So
I'm still waiting on a reserve decision for that.
Shocking, isn't it?
I think I'm going to get more reserve decisions than actual answers.
Yeah, well, they like to jump on that. Anything that's on the too hard basket, they'll put a reserve decision in there and then spend 3 months to 9 months fucking giving you an answer.
Yeah, but they don't got the ability to, though. You see, the reserve judgments under the Judicial Conduct Part is 2019. They have to have it out to you within 3 months if they're a district court judge.
Oh, really?
Yep. It's only Supreme Court judges that can go to a year. And I think it's High Court can go for 6 months.
Right.
Yeah.
Well, that would make
Because I was
sense.
looking through those wondering, okay, like, what is the actual time frame period? Because I know that, like, when I was reading the Supreme Court rules, and I was like, oh my god, they can take up to a year for a reserve judgment.
Right.
What gets me is when you get cases like old Peter Ellis's one. Okay, we'll wait till the man dies and then say he didn't do it.
Yeah, of course. Yeah, but late after the fact.
Yeah. So it's just toddling on here now, waiting to find out. Okay, number one, the first thing we're going to find out is who's the family court judge that we're going to deal with.
Yeah, because it ain't going to be Judge Black.
But is it good? Is Jean Gray put it to me? Are you going to end up with someone who's going to do worse now because they know that you've managed to get rid of a judge?
Yeah, the old you're better with the pricks you know than the pricks you don't. You're going to fall into a rose bush.
Well, I mean, realistically, what it comes down to, I mean, like, even when I was younger, okay, at the end of the day, if there's a challenge in front of me, you've got to find a way around the challenge. You don't just let them beat you.
Yeah, exactly. Yeah.
And unfortunately, that's one of those things. I mean, like, it's unfortunate Black thinks he's been bullied when he's been the bully for the 5 years.
Yeah,
but at the end of the day, I mean, when it comes to the judicial review, I'm going to say the same thing when we go to the hearing. At the end of the day, if I'm a bully here, you need to fix your system, don't you? Because I used your system to be able to do it legally.
Yeah.
So if I'm a bully for that reason, you need to fix your system.
Yeah. Close the loopholes or remove the things that assisted you. But don't bitch about it.
If you remove the things that did that, right, then, or if you remove the problems, then they're going to have to start with the new judiciary because they're all a problem.
Yeah, well, exactly. But I mean, that's all I can say is more people need to start taking torts of professional negligence against the lawyers, against the registrars, or even a stern talking to like the Manukau guy, like the Manukau registrar that thought he'd breached the other lady's privacy by talking to her about you, to you.
Mm-hmm.
What a fucking idiot!
It's just weird how they do things. I mean, like, there's been a few different registrars I've spoken to around the country now, and the last one at the Manukau, in the end when the actual registrar came out, he then refused to speak to the person who wanted to put the form in. He got up and he walked away, apparently.
So then what happened? Did they get it filed, or?
She left it there for it to be filed. He said that he would put it through for the filing, but on the basis that he was not prepared to deal with it.
Yeah, but she should still receive an acknowledgement of the filing in some form, even just by email.
Oh, yeah. No, he's told her that it wouldn't go on the system until Monday, because it was in the afternoon on Friday.
Yeah.
Which is understandable.
They work on Saturday. I'm always getting emails from the registrar telling me new dates, and it's always a Saturday I get them.
Yes, and the other interesting thing about without notice system is this: if it happens to be after 11 p.m. at night that like a lawyer puts one through,
yeah,
it's actually not a judge that actually goes on the system and approves it. It's a JP with judicial status.
Oh, really? So old Selwyn Hayworth could even stick his nose in. Prick.
Yeah, so what happens is, apparently, even though the duty system runs 24/7, after 11 p.m. at night, you don't get any judges dealing with this.
It's just JPs. It's like,
JPs
how dare they wake up a judge to do his job?
Well, yeah, it's on the basis that if the JP was wrong, then the judge can
can correct the error. You're right.
Yeah.
Gives them a loophole out.
It's a pity the rest of them don't work that way, because I mean, with all the errors that they make, it's just unbelievable. Some of them, like we got one now where the OT is now backed away from the case because the judge backed away and recused herself.
What's the count? What's the count at the moment? How many people have you got their kids back, or at least assisted just this year, mate? Because I know you've fucking been full on helping people.
I mean, I know for over the total of the 3 years since I started self-representing with my granddaughter's case when it first happened, there's been. I'm pretty sure it's now around 9 or 10 that have gone home.
That's brilliant.
And we have quite a few that are step by step getting through the system and getting out of the system. We just had another one. The support order has now been lapsed, so OT's nothing involved in it. That one there, the other child, the judge has seen that there was issues with the appeal that went through the High Court,
right?
And is now trying to sort those issues out, because that child should have been back with his mother in 2016.
That's a long time. That's 7 years. The mother's lost any connection with that child for such a long time.
Luckily, we've managed to keep the contact in play.
Good.
So they don't have the ability to be able to turn around and go, they say, well, you haven't had any contact with the child, so the child doesn't know you.
Sure.
Okay. Well, they don't have that thing. And here's the weird thing. Okay. They wanted to turn around and give the child to the caregiver, right, and permanently. Okay. But they've screwed up so much that they had the caregiver applying for custody, but mum having unsupervised access with the outlook to coming home.
All right.
So they're trying to figure out, how do we get around this? The family court screwed up. Okay, so they went and appealed it. The High Court backed up the decision and screwed up, even though they could see that the event that happened in 2016 had been overturned and that the child should never have been out of the mother's care. Right.
So the High Court screwed up as well.
Yeah. So then the judge jumped ship on the case.
Right.
Right. The judge jumped ship on the younger child's case and transferred the case for the older child back to Otho. So she's jumped ship on everything, because she's also this. We've done it. We've got her on so far 3 different jurisdictional issues where she never had jurisdiction to make orders.
But they do anyway, because it's their court and they can do as they like.
When was it? 2020. Yeah, last year, 2020. Oh yeah, 2022. I think it was. We did paperwork in December 21. November, December 21. We did memorandum next court, reminding them reminding the judge what she had done. And I said to the mother's advocate, okay, what will end up happening is, they'd be surprised if the judge deals with it in chambers, because they won't want to go through a hearing and have to deal with the other party going, no.
Oh, they don't want a record being made. Neither.
So all of a sudden in February 2022, late February, early March 2022, a minute came out with orders discharged.
What a shocker!
And no hearing, Chambers decision.
Yeah.
On the basis of this, if the court does not do the right thing when it did not have jurisdiction to do it in the first place, remedial action will be taken against the court.
Wow. I wouldn't like that.
What about the torts back then? But just write remedial action will be taken, just to see what happened. and then the judge discharged the order, and then 6 months later it's gone.
I should throw that on my submissions in support of the dismissal.
Yeah, I mean, when it comes to that's what I always put. Because at the end of the day, if they're not doing what they should be doing, you're going to seek remedial action. They don't know what the remedial action is. So as far as I mean, it's sort of a bluff. Okay, but at the end of the day, if they're pissed off enough, then you just follow through on the bluff.
Yeah, exactly. Because you've always got the right to appeal or do a judicial review on the procedures.
Yeah, and the other thing that that I've come to learn lately through Justice Palmer is, okay, it doesn't matter when you're going through, even through criminal court, you just have to have something of finality. Like Judge Harrop said this as well. Okay, if a final date has been set for a hearing, okay,
yeah,
you have the ability to appeal that date. So like you go to like your pre-hearing one, and then they just give you a hearing date for later on, right?
Oh,
so
sure, yeah.
Right.
The first
So,
call, and yep.
Yeah. So when they turn around and say to you, "We're going to have a judge-alone trial on this day,"
Yep.
right? There you are able to turn around and appeal if you want to, because okay, well, no, I didn't say the court could make any decisions.
Right, and
Yeah.
they'd already made a decision for that date.
Yeah, well, they've made a decision that they're going to hear your trial on that date, so that's a decision. So you can now go and appeal it.
Depending on how much of a complete wanker you want to be for the court system.
Exactly. But I mean, at the end of the day, at the end of the day, you have the right to appeal it.
Of course you do.
Someone can set a date.
Yeah.
You know, and so I guess I know a bit about the family court.
Well, hey,
I'm still reading about the criminal court. But,
yeah. Because what we were saying about you were telling me about solicitors and solicitors having the ability to access criminal records and file charges. Solicitors versus barristers sort of thing.
This is how the Commerce Commission did it. Okay? If you've got a solicitor and that solicitor believes that yes, you are right with criminal charges should be laid, okay, you don't have to go through the rigmarole we go through. The solicitor is a barrister can't do it apparently, but a solicitor can solicit the charges through the Crimes Act through the CPA.
Through the criminal procedure act. Yeah.
Yeah, so how I was doing that 13818,
yep.
That's exactly how they solicit the charges in. They just make sure there's at least two, and then that way they're able to bring the charges into the court.
So as long as there's two or more charges, and it's not that bloody hard to think up two charges or more.
Which you just reminded me, I also have another judicial review to do.
Oh, sorry.
Because, no, that's all good, because that's the one where Black turned around and in his footnote on the first page, stated that I must have done a typographical error, and because of that reason he's ignoring the contents of the charge, and for that reason that's why it was dismissed.
God's sakes.
The only typographical error was not knocking the button.
Did he leave a slime as he slithered out of the courtroom, for fuck's sake? Jesus.
He had that, you know, where you see them just get up and just like, he reminds me of the Count Dracula in that kids movie.
Oh, right.
Just sort of up inside.
Yeah, just slithered.
Yeah, because he actually, on the day of the recusal hearing, that was.
Hi Tim, if you're watching, g'day Timmy. Just wanted to make sure, you know.
Oh no, nothing's worse than Timmy with authority.
But it's one of those ones where. The one thing I have learned about the whole family system is this. If you're a parent and you're going through the Care of Children Act, and you want to be able to have some sort of agreement with your ex in regards to how your child should be looked after, even if you don't agree fully together, just agree to whatever you need to get a final order in place. Because once you've done that, okay, that's the end of it in the family court. You're now going to go to the High Court. The High Court's going to turn around and say, well, you agreed to this. No, I agreed to certain aspects of it. However, I still did not believe it was in the best interest of the child, and therefore, because of that, I am appealing certain parts of it.
And you go to the High Court, basically to get it out of the jurisdiction of the family court.
Exactly, because the way the High Court looks at it is that unless you've got finality under 1431A of the Care of Children Act,
yep.
Okay, and so people look at it and go, well, I can't appeal. And lawyers tell them, no, you can't appeal because we just made the application and the judge refused to make any type of order. Well, 1431A of the Care of Children Act specifically states, makes or refuses to make an order.
Right.
So by refusing to make an order, they've given a final decision. It's not an interim decision, like they say.
Sure.
And therefore you now have the ability to appeal. But the lawyers tell them, no, we don't have the ability to appeal because the judge refused to make the order. Yeah, and I get that, but that's one of the whole grounds for appealing.
And there was something else you were saying about disclosure. When you're wanting, what was it? Disclosure if whether or not the prosecutor will give you the disclosure because whether they think it's relevant, and it's not up to the prosecutor.
It's not up to them whether it's relevant or not. I mean,
it's up to the judge, so it must be supplied.
Everything must be supplied, which is why when it comes down to prosecutors, that's why I used 24A and D of the New Zealand BORA instead of the CPA as a sort of criminal disclosure, because see how they're giving you guys the extra stuff afterwards, that the ability to give me anymore.
Yeah, because you asked for full and final disclosure into 24A,
and so
which we've done as well, but they're still doing it.
But here's the interesting thing, though: they tried to bring more in at the actual hearing. The judge said it's not part of the bundle.
Yeah, nice. Yeah, because I'm going to be putting all the submissions and everything in a big bundle for them.
Full and final disclosure under 24A and D, and so once the final disclosure was given, there's no ability to draw upon more against.
Yeah, well, and that's my argument too. The Section 30 order was made, 30 days was given, so after that 30 days, nothing else should be admissible under Section 130 of the Evidence Act, because they're now in breach of the court order if they want to try and put anything else in.
Exactly,
which is absolute grounds for a 147 dismissal. So.
Yep, and you know what will end up happening instead of that more than likely?
Awesome.
And I would weigh money on this. A judge will turn around and say, well, I require the information to make an informed decision.
Yep, and if I supply all of that information as authorities in the bundle, he's been informed.
Yeah, but they don't look at it from that point of view because it's their interpretation, remember?
Or it's not hard to interpretation facts that are presented in the bundle. I mean, I simply say, this happened on this date, and here's your own court transcript confirming what I'm saying happened. You know, this happened on this date, here's the document that proves it. So they can't argue with documents that they have.
The problem you run into, though, that I've seen in a couple of Supreme Court transcripts and that as well where the judges have been talking about it, is there's these very famous words that judges use. Well, of my own motion, I strike at that and written out.
Yeah. Of my own motion. So they're passing their own.
Although, when you get to district court, if they turn around and say of my own motion, you can literally turn around and say nothing is occurring today, Your Honour. Well, why would that be? You didn't do it of your own initiative.
Okay.
Only the High Court and above can do of my own motion.
So district courts can't pull that off, but they'll try it if they can.
The reason being, you have to have inherent jurisdiction to do of my own motion.
And only the High Court has inherent jurisdiction.
That's right. So when it comes down to that, like, I noticed that at one stage when I mentioned that in the family court, Blackwell said, well, of my own initiative, I do this thing.
You can't do that.
And it's one of those things where you sort of feel like to say to yourself, well, then how are you going to do that because you don't have any initiative either. Nor intelligence. Yeah, exactly.
Yeah. Well, it's going to be fantastic to see old Judge Black knock down a peg or two. And obviously now he's a victim of bullying, so I hope he gets counselling and gets that sorted out because, we want him to be impartial, don't we?
Counselling? I think we should send him to family court, and I mean, he should get all of the required reports under a 133.
Yeah, get a psychological evaluation straight the fuck away.
No, let's never mind that one. We'll go for the mental health because that's.
Oh well, I think.
We'll just go for a compulsory one,
Yeah. Well, I think we've covered enough about old Timmy tonight. So.
Yeah. Oh, good, mate. Okay, well, I'll leave you to it because I'm going to go and fill some chips.
Yeah, I see your burger rings there. Go hard. Yeah.
Okay, man, have a good one.
Alright, you too, bro. Thanks.
Yeah, see you.
Catch you.
Bye.
Oh no, nothing's worse than Timmy with authority.
Bye-bye now.